This week, we will be taking a look at the Texas court system. Learning objectives for this lecture: distinguish between civil cases and criminal cases within the legal system, discuss judicial federalism, explain the structure of the court, describe the methods of judicial selection, and discuss judicial selection in Texas. Let's begin with understanding the legal system. The American legal system can be broadly divided into civil, criminal, and family. Civil cases are between individual citizens and involve individual responsibility, not guilt. Criminal cases are brought against individuals for violations of the law, crimes against society. Family law includes cases related to marriage, divorce, child custody, and age consent, among other issues. Under civil law, all those who believe they have cause or have been injured may file a lawsuit, and the courts decide if the case has validity and should be heard. A grand jury. Criminal allegations may be reviewed by a grand jury or information or administrative hearing. Texas uses both. A citizen may waive grand jury review and ask that a judge review the charges. Grand juries consist of 12 citizens chosen by district judges. Most juries serve for 6 months, screening major cases to decide whether enough evidence exists to go to trial. Grand juries are meant to prevent arbitrary actions by prosecuting attorneys, but they do not always do so, as the district attorney often dominates and grand jury members frequently follow the advice of prosecuting attorneys. Petty juries that can be decided by criminal and civil cases. A jury pool may be selected randomly from voter registration lists or from a list of licensed drivers. Defendants have the right to a trial by jury, but may waive this right and let the judge decide the case. Most people charged with a criminal plead guilty, often in exchange for a lighter sentence. Fewer than 5,000 of over 1 million cases each year result in jury trials. Judicial federalism. The U.S. Constitution establishes the Supreme Court, gives Congress the authority to create lower courts, and makes federal law the supreme law of the land. Any direct conflicts with state law must be resolved in favor of federal authority. 50 states separate jurisdictions have complete court systems that exist side by side with the federal courts. The nation's dual court system developed because of our federal system of government. State courts act where the federal government lacks authority. The structure of states' courts. Most state court systems have 3 levels: trial, appellate, and a Supreme Court. Texas has several levels of trial and appellate courts and has 2 Supreme Appellate Courts. For civil cases, the Supreme Court; for criminal cases, the Court of Criminal Appeals. This slide contains a visualization of the court structure of Texas. At the very top, you see the Supreme Court and the Court of Criminal Appeals, followed by the Courts of Appeals, district courts, county court levels, and then you have the Justice of the Peace and the municipal courts. Trial and appellate courts. Trial courts are local, with jurisdictions limited to a geographic area, such as a county. One judge presides, citizens serve on juries as witnesses. The primary concern is establishing the facts of a case, including determining whether a person is guilty. Decisions are announced immediately. In appellate courts, they're often centralized, often at the state level. More than one judge presides. Points of law rather than facts are decided. Magistrate or minor courts. These are usually called the Justice of the Peace. These courts hear cases involving misdemeanors. The Texas Constitution creates Justice of the Peace, or JPs, and the legislature creates multiple courts by statute. Some municipal courts are courts of record, creating a transcript that can be reviewed. Other municipal courts, and with JPs, are trial de novo courts, meaning no record is kept and cases may be appealed for any reason. JPs perform magistration functions, hear minor criminal cases such as small claims court, and can perform marriages. County courts. County courts hear intermediate criminal and civil cases, serve as appellate courts for cases heard by JP and municipal courts. Texas has a constitutional county court created by the Constitution for each of the 254 counties. The Constitution determines jurisdiction. The Texas legislature has created 249 statutory county courts at law in large urban counties and 18 probate courts. Jurisdiction varies according to the act creating the court. District courts and appellate courts. In most cases, major trial courts are called district or superior courts. Major criminal and civil cases are heard. As of January 2020, Texas had 477 district courts created by the legislature, often with overlapping jurisdiction. 9 states and the District of Columbia do not have courts of appeals, and 30 states have only 1. Texas has 14 with 80 elected judges. These courts hear all civil appeal cases and all criminal appeals, except those involving the death penalty, which go directly to the Court of Criminal Appeals, which is the highest court. The Supreme Courts. All states have a Supreme Court, or court of last resort. Oklahoma and Texas each have 2. In Texas, the highest court for civil matters is the Texas Supreme Court, and the highest court for criminal cases is the Court of Criminal Appeals. Each consists of 9 elected judges elected statewide for 6 overlapping years. Judicial selection. All federal judges are appointed by the president and serve for life. Among the states, a variety of methods are used. Appointment by governor to serve for life, election by a legislator, partisan elections and nonpartisan elections, the merit system or Missouri system, whereby the governor appoints a judge from a screened list and the judges serve for a set term and then stands for a retention election. And finally, the method of selection also varies between courts within some states. This slide contains the various methods of selecting judges. You have legislative elections. There are mainly 3 states that use this, all the way to merit plan, which is about 20 states that use this, and so on and so forth. This table shows judges who are nominally selected. Some judges in partisan and some in nonpartisan systems may have their initial seat appointed by the governor. Note that South Carolina and Virginia elect a Supreme Court judge legislatively. Appointment by the governor. Gubernatorial appointment does not ensure competence. Appointments may be used to reward friends and repay political debts. Governors, like U.S. presidents, use the judicial appointment powers to select judges with political philosophies similar to their own. The best candidates may not agree to serve. Once appointed, judges are not responsive to voters and can exercise great independence. Election by the legislature. Used only in South Carolina and Virginia, this system tends to select former legislators as judges. Discontent over questions of judicial independence in South Carolina in 1996 led to the creation of a quasi-hybrid method of judicial selection with a merit component. A judicial merit selection committee reviews the applicant's qualifications and nominates the 3 most qualified. The new rules also require a year's separation between the legislative service and the nomination to the judiciary. Partisan elections and nonpartisan elections. In partisan elections of judges, party identification is shown on the ballot. Texas uses this system, although nonpartisan elections is being given a serious consideration. Election is meant to make judges more accountable, but partisan elections raise the potential of judges being subject to political demands. Partisan elections remain the most used system for trial judges. The merit plan. With this method, used in many states, the governor appoints judges from a list supplied by judicial panel, perhaps ranked by the state bar. The judge serves for a set term, followed by an election. The merit plan seems strong on the issue of competency and responsiveness, but there is little evidence that the results in the selection are of more competent judges. No perfect system exists for selecting judges. Judicial selection in Texas is partisan elections. In Texas, trial courts are elected in partisan elections for 4-year terms and appellate court judges for 6-year terms. Municipal court judges are usually appointed by the mayor or the city council. Judicial selections have been an ongoing issue. Most Texans don't want to give up the right to elect judges. Several other issues with judicial selection in Texas have been raised. The appointive elective system. Reformers have called for change to Texas's judicial selection process, with both partisan and merit systems suggested. Some point out that the state already has an appointive elective system, with many judges gaining the initial seat by being appointed and then later standing for election. Historically, many judges in Texas initially receive their seats on court appointments. Familiar names can skew judicial elections. Voters are asked to elect judges for the Texas Supreme Court, the Court of Criminal Appeals, several district courts, county court judges, and JPs. Most have little knowledge about the candidate's qualifications and wind up for voting for name familiarity. Straight ticket voting system allows a voter to vote for all candidates in a party by making a single mark. Texas is among 9 states to allow it. Candidates may lack judicial experience or may have no courtroom experience whatsoever. In 2017 legislative session, Texas passed House Bill 5 to get rid of straight ticket voting in 2020. A similar change in Michigan in 2016 occurred. However, it was struck down by the courts because it disproportionately affected African Americans. Campaign contributions. In Texas, judges must win nomination in the party primary and in the general election, which combined can be a costly process. For example, in 2018, the Texas Supreme Court Justices Jimmy Backlock and John Devine raised over $1 million for re-election. Money often comes from law firms with businesses before the same judges who receive the money. Other money comes from interest groups and corporate donations that have steadily grown. Do contributions influence judges' decisions? Cases filed by large contributors are more likely to be heard. Gender and minority representation in the Texas judiciary. Electing judges from a diverse array of backgrounds is meant to lessen whatever bias may exist. In Texas, approximately 49.7% of the general population is male, but over 60% of the judges are male. Approximately 41% of Texans identify themselves as white and non-Hispanic. 39.6% are Hispanic or Latino, but only 32% of all justices identify as non-white. About 12.8% of the population is African American, but only 5.4% of all state judges are Black. Conclusion. The court system in Texas faces many challenges. Methods of selecting judges will continue to be controversial. Problems in the electoral process and issues of representativeness pose challenges for the judiciary. Some change will probably occur, as evidenced by HB 5 prohibiting straight ticket voting back in 2020. Thanks for listening.